kick us off. Hello, and welcome to So a Neighbor Asked. This is a monthly series from Mountain States Legal Foundation, where our attorneys answer your questions to help you understand the Constitution, the law, and the principles of liberty. I'm your host, Stanton Skrjanik. I'm the communications manager here at Mountain States. Before we begin, I want to introduce you to Mountain States if you've not been with us before. MSLF is a nonprofit, public interest law firm dedicated to restoring those rights enshrined in the Constitution at zero legal cost to our clients. We are focused on protecting property rights, economic liberty, the right to keep and bear arms, free speech and association, and equality under the law. From our headquarters in beautiful Colorado, we litigate those crucial cases across the country at every level, especially those that are going to make a difference in our country. And I am joined today by some amazing panelists here, and they're going to help us answer a very important question. What is originalism? The Supreme Court's recent term ended with a pretty big bang as it struck down gun control laws in New York, reined in the bureaucracy that got out of control, and overturned Roe v. Wade. And in the span of a month, it seemed like the court accomplished huge victories for the Constitution. Leading the charge, we might say, is Clarence Thomas, who we could describe as the great originalist of our time. But what does that mean? What does it mean to be an originalist? Is it something new?
I believe the term is bloodthirsty originalist.
Bloodthirsty originalist.
Yeah.
Okay, well, even more important then, what does it look like for bloodthirsty originalists to control the future? What does that look like? Like I said, I'm joined by some great panelists. One of them is MSLF attorney Kaitlyn Schiraldi, and the other is MSLF attorney David McDonald. And our special guest, I'm going to let Kaitlyn introduce.
So we are very pleased to have Brandon James Smith. He is the Assistant Solicitor General and Director of Policy and Federalism at the Tennessee Attorney General's Office. So he's held many positions before this. Brandon was the Executive Director in the Office of Legislative and Regulatory Affairs for Kentucky Governor Matt Bevin, Policy Director for the Office of Kansas Governor Sam Brownback, and a Deputy Director at the Federalist Society, among others. He is also my colleague, as we are both members of the Nashville Federalist Society Young Lawyers Committee. So welcome, Brandon. Thank you for joining us.
Thank you. And as I've told Kaitlyn, I think I'm pushing the limit of what constitutes a young attorney, but I'm going to hold on to it as long as I can.
You still got more dark than gray in that hair. I think you're good, right?
Yeah. I think that qualifies. We'll count that. We'll pass the membership clause along. So everyone, let's go ahead and get to it. Kaitlyn, David, Brandon. By the way, before we really get started, for our viewers online, we're going to chat here for about a half hour or so, and then we're going to do a question and answer session to close out the episode. If you're joining us via Zoom, you can find at the bottom a kind of Q&A portal where you can ask your questions. If you are on Facebook for our Facebook Live, we're going to do our best to grab some of your questions from the comment section. So now that I've said that, Kaitlyn, David, and Brandon, help me out here. I'm not an attorney. Y'all have been talking nonstop about originalism since the term ended. What is this thing? Give me the basics here. What are we talking about?
I'm happy to start us off. So I want to address two things as we begin this webinar. In lawyerly fashion, I have 2 points to make. So the first is I would like to talk about the definition of originalism and how does one actually discern original meaning. So originalism is a theory that the meaning of the words in the Constitution were fixed at the time they were written and ratified. And conversely, there are legal theories that treat the Constitution as a living document with no fixed meaning. And that means that it's subject to changing interpretations according to the spirit of the times or the views of judges who decide these cases. I first learned about originalism in my statutory interpretation class because the same way that you can go down the list of how to interpret the Constitution, you can do the same for, judges can do the same to interpret statutes. And I've been drawn to learning more about it ever since. And to discern the original meaning of words when the Constitution was ratified, there's kind of a layered approach to doing so. So you can read the plain language of the Constitution. You can ask, what did those words mean at the time that they were drafted, which means you can consult maybe a dictionary from the time period, or how does that word fit in the puzzle piece of the Constitution as a whole? What did those words mean to the framers whenever they suggested the language, or commentary from ratification debates? So there are many ways that you can discern original meaning, but the whole point of originalism is so that we're governed by the rule of law and not the rule of men.
You say they're reading, these people who are originalists, they're reading dictionaries from like 1787. Is that really what it is? Just finding an old dictionary?
That's part of it. And it's hard to find those sources. You have to do a lot of sleuthing as an attorney to find old dictionaries like that.
All right, David, are we on par here? Is that your similar understanding?
Yeah, I think Kaitlyn had a great explanation there. I think that's pretty close to the textbook definition. Mine's a bit more flippant than that. My definition of originalism is the definition we use in literally every context other than constitutional law, which is reading. That's all we're really doing. And it's not, it comes across as flippant, but think about it in the context of anything else you read. Like when we were all first introduced to Shakespeare in high school, and that first book is kind of the No Fear Shakespeare. You got the original text on one side, the translation on the other side.
Yeah.
If you attempt to give a 14-year-old Shakespeare in the original text and have them understand, it's going to be impenetrable to them. They're not going to understand. Or say if today you read the phrase to quell dissent, that means to have a rational, calm discussion with your detractors about what their concerns are and coming to rapprochement about it. In the reign of James I, to quell dissent meant to murder everyone who was dissenting. Words change over time, and that's really important to recognize. And in every other context, everyone acknowledges that's just what we do when we're reading old documents.
Okay, I'm glad quell doesn't mean murder now, so I guess no, I won't quell that. Brandon, no, you're the assistant solicitor general. How does that play for you? How does this definition work for you in your office?
Yeah, I think Kaitlyn and David are right here. Originalism is essentially just the assertion that in interpreting the Constitution or statutes, that the statements that are interpreted must be done so based on the original understanding of what those words meant at the time. Justice Thomas would have added to that when we read something that someone else wrote, we give those words and phrases their natural meaning in context. So David's not so flippant response is really pretty accurate. Like, just read it. What does it say? And sometimes that's a hard question, but the point is that's the question. That's the question you start with. I think in practice it becomes pretty difficult because originalism has a habit of often resulting in conclusions about the meaning of statements or the meaning of a constitutional provision that you may or may not like. Originalism doesn't really care about your feelings. It just is what it is at the end of the day. So sometimes we'll be working, it's not infrequent that our office, for example, will have a case that, we'd like to be more aggressive or challenge something, but the law says what it says. The Constitution says what it says at the end of the day. And
so Brandon,
I sort of make it up as we go.
You said something pretty interesting. You might interpret something and you don't like what the meaning is if you're looking at the original, the original understanding. I guess from my end, when I read the news or I'm watching whatever talk show, that all the originalists were Republican appointed. Are there such thing as liberal originalists or conservative originalists, or is that just a fake label that we're trying to add on here?
Yeah, I think it was, I'm going to maybe get this wrong, but I think it might have been Justice Kagan who once wrote, "We're all originalists now." And of course, I think there's some disagreements at times between Justice Kagan and Justice Thomas's approach to originalism. As you can imagine, no one's going to be shocked by that. But it has been interesting over the last probably 10 years or so to see the court's analysis of some of these constitutional interpretation questions really narrow in on questions of original meaning. It's no longer just the classic Ruth Bader Ginsburg living Constitution or Breyer living Constitution perspective put up against some of the more Republican appointed justices' position of originalism. we're really seeing judges and jurists on all sides of the aisle engaging in this sort of analysis. And I think part of the reason is to do to the fact that this approach just makes more sense. It's a more logical, rational, and at times easy way to approach a question. Now, answering that question is often not easy and is frequently very complicated. But I think what we're talking about with originalism is what is the question we're asking first, and not what is the result we're trying to get. And I think that's the difference between originalism and many other approaches to constitutional interpretation. Many are post hoc rationalizations. I feel like I should be able to do this, so I'm going to go find a constitutional right that says I can. Originalism starts with, what does the Constitution say? What rights does it give you? What structure does it enforce in our government? And then we're left to deal with the consequences of that.
So that actually brings up. Oh, go ahead, David.
Oh, I just wanted to add on to that really quick. That when you're dealing with oh, sorry, I completely missed my point when I was interrupting. I apologize. Continue, Stanton.
That's okay. I had a follow-up. I have a follow-up to you as well, Stan. So when you're asking, is it just Republicans or, who thinks that originalism is maybe the best way to interpret the Constitution? Ronald Reagan has a really good quote where he says that judges shouldn't be liberal or conservative since the Constitution isn't liberal or conservative. So I thought that was the perfect answer to your question.
I do remember my point. I do remember my point now. The point here is that will originalism prevent dedicated bad faith judges who want to get the result they want from doing it? No theory of interpretation will. But what originalism does is it puts guardrails on that bridge. At the end of the day, if a judge wants to get to a certain result, they can find a way to do it. They're all very smart people. They can find their way around it. But originalism is really the only method of interpretation that provides any restriction on that impulse at all. Because at the end of the day, you have to point to a historical document that says what you say it says. None of this can be pulled completely from the ether. So I think originalism may not be perfect, but I think it would be a mistake to let the perfect be the enemy of the good.
I want to ask a question about that. That no decision is pulled from the ether, because I feel like, when I taught American government at the high school level, I'm like, there seems to be some decisions pulled from the ether. So I want to ask this way: is originalism something new? Has it been used in the past to interpret the Constitution? No. Why was this year such a big deal? What's come before this major year of 2022? What's been going on before then? Brand, you mentioned some other ways to interpret the Constitution. I'm saying that there might be some there. I mean, for every non-lawyer, it does seem like lawyers pull things out of the ether. So, I'm just trying to wrap my head around this.
I did a little bit of digging on this, and the phrase original meaning was actually it first appeared in a Yale law journal in the 30s, but the term originalism wasn't found in Westlaw periodicals until the 80s. And I think that kind of aligns with Attorney General Edwin Meese was giving a bunch of speeches in the 80s, and he was urging judges to embrace a jurisprudence of original intention. And that also coincided with, Antonin Scalia being put on the Supreme Court in 86. And so I think the 80s were a really big, a pivotal moment for originalism. And, it was funny. I looked up one of Edwin Meese's speeches, and he was talking about how a leading case book in the 80s for law schools on constitutional law put the Constitution in Appendix H. So they're learning about the Constitution. It's not even within, in the forefront of the textbook itself. Yeah. So I think he was really the impetus he accelerated this in the 80s, maybe started it, accelerated it. And then from the 80s onward, we have so much more research on what the framers meant. We're able to dig up more documents and do more thorough historical research because so many scholarly papers have been published from the 80s till now that we can rely on when we cite these things in our briefs.
Appendix H, talk about showing your true colors there.
Right.
Right.
Yeah, I think that's right. The term itself is a little bit newer. I mean, and by newer, we're saying the 80s is not that long ago. But the concept is a quite old one. Justice Thomas would say that there's only two ways to interpret the Constitution: to try our best to discern what we can from what the framers were doing, or just to make it up. And you see some of that struggle during the New Deal era, and particularly when the pre-New Deal court was wrestling with questions of substantive due process and what the meaning of the text of the Constitution was, or what this provision meant. That none of that concept is new. What's new is exactly what Kaitlyn has pointed out. In the 70s and 80s, there was actually a series of debates. So it started, I think, originally with a book written by, or an article written by Judge Robert Bork, who was famously borked or not appointed to the Supreme Court with his confirmation getting derailed.
Right.
Ed Meese took up the cause, and the context there was really pushing back on some intellectual developments at the Yale Law School. There was a growing movement called legal realism, which was seeking to impose essentially policy preferences and societal considerations in determining the meaning of constitutional text. This sparked a lot of people at the time to get really nervous, because this theory of legal realism was starting to become quite popular. It was almost considered as the inevitable conclusion of our constitutional questioning. So what you have then is Ed Meese starts giving speeches. Justice Breyer responds in a speech. Ronald Reagan gives a speech kind of responding to both of them. And then this sort of just goes like back and forth over the course of about 8 years throughout the Reagan administration. And you see these like really, really bright legal minds at the top echelons of government and the judiciary and the academy just really trying to figure out what's going on and where we're going to go from there. And that's really when the term started becoming used as like as how we use it today. But since then, Kaitlyn's right. Like, we've just seen an explosion in research, an explosion in understanding what the original meaning of the text was. We've even seen debates within originalism. We've kind of brushed over that point, but originalists frequently disagree with each other on what originalism ought to mean. So we're doing kind of like big picture what it means, but there were for many years and still to some extent today a heated debate over textualism versus original intent versus versus original meaning. And those are all like kind of nerdy distinctions between lawyers who have little else to do but to write papers and debate each other. But those questions are important. And then the answers to those questions are important. So, okay, sure, we've now agreed we're going to ask, what does Article 1, Section 4 mean? But then the answer to that question, of course, is often debated and different. And that's where we see a lot of, I think, really interesting things happening, because we've already created this originalist framework for understanding the Constitution. And it really serves as a great guardrail for focusing our debates, both politically or within each side of a political or legal philosophical movement, as to the meaning of the Constitution. But the context and the history there really is just kind of remarkable. The 80s is when you're also not just seeing sort of the Reagan Revolution, but we're seeing the heating up of the judicial confirmation process. We're seeing the founding and beginning developments of the Federalist Society. I mean, this was really sort of a keystone moment in legal academic history, for sure.
Yeah, I mean, the late 70s and kind of the 80s is when a lot of these constitution-loving legal foundations like Mountain State started to pop up and really accelerate their work in the 80s. Because Pacific Legal, Mountain State, we've been around for a while, and it's at that time that you're right, that originalism really did start to kind of heat up as this big thing of what does the Constitution actually mean. Dave, do you have anything else to say? Because I got another question here.
Yeah, just really quick on that. I'd say while the name and the terminology is young, I think the joke I hear from my non-religious friends is that it's younger than Kim Kardashian, which technically true in only the misleading way that technically true things can be. But if you look at the opinions of John Marshall, like those are originalist opinions. He didn't call them that, but it's not until you get into the sort of the run up to the Civil War with the Taney Court with Dred Scott and all that you start seeing a move away from let's look at what the text said in the context of the time and started moving towards that seems like a really bad idea. So let's try something else. Like that's really an innovation of the antebellum.
So David, just to be clear, when you say John Marshall, you're talking about the third Chief Justice of the United States?
Yeah, the first one anyone remembers. Yeah,
the first one anyone remembers. So that actually has here's a follow-up question. If back then, that's the first generation, that's really they are the original list. They wrote what we're talking about. Why would anyone disagree back then on the meaning of the Constitution? Why was there any disagreement?
Yeah, so I think this gets to kind of one of the internal originalism debates kind of between original intent and what is kind of supplanted it as the main branch of originalism, its original public meaning, is you run into this issue with any kind of statute, constitutional provision, anything created by a committee, is that if you ask the members of the committee what they think is most important, what they think the statute means, you might get 10, 15, 20, 435 different answers on that.
You have different intended meanings.
Right, exactly. James Madison had a very different conception of federal power than Alexander Hamilton did. But they were both co-authors on the Federalist Papers. So you have this issue where, and John Marshall, I think, is a really great example of this as someone who was an explicitly political actor, even once he was on the court. He was a Federalist first, a Justice second. Let's not get that past. I think he would be okay with that characterization. But you have that issue is that the people who were there might have had different ideas. So that's why we don't look towards the inchoate intentions of some combination of members who might have voted it. We looked at the text because the text is the thing that was passed. The text is the thing that was ratified. And we look to what the ordinary man of general understanding, whatever that term is that we use in whatever decade we're in, what they would have understood the Constitution will be. And that will leave some ambiguity in some cases, but it gives you a really good place to start.
So text over intent, because text is the only thing that is common. Is that the kind of the gist of that?
Right. Yeah. So the intent wasn't passed into law. The text was. So they might have had really, really great intent. They might have. So I think this comes up a lot in 14th Amendment jurisprudence. Is every single person alive, more or less, in 1865 would be considered a horrible racist by today's standards. So there's all kinds of things where the men who wrote the 14th Amendment may have had secret bad ideas in their hearts, but the text they wrote is the 14th Amendment we have, which is a beautiful statement of equality and due process. So it's important to look at the document that we have rather than the secrets inside the hearts of the legislatures.
Okay. So I hear all of you, and I'm getting the sense of what originalism is, and I'm starting to hear why we think it's better. But I'm going to ask this straight up: why should I trust Clarence Thomas on reading the Constitution over Stephen Breyer, who just retired, or why should I even trust Thomas to say John Roberts? What is it exactly about originalism that makes it better than any other test?
I think here, I'm sure there'll be a lot of great answers that the other panelists will give, but one thing that every single person listening, watching this can do is they can go look up the voting records of the members of the Supreme Court, and you'll see the people who quote unquote defect from their party are almost exclusively the ones calling themselves originalists. Stephen Breyer never wrote a decision he didn't agree with. Clarence Thomas does that all the time. So I think the proof's in the pudding there.
Okay.
There's a really good quote that I like from Justice Scalia where it talks about why he believed in originalism, and that kind of solidifies why I think this is the best way to interpret the Constitution. He said, if you don't take the words of the Constitution and what they were originally understood to mean, what is the standard? The answer is there isn't any standard. Mm-hmm. So I think in my opinion, it's the best nonpartisan way to make decisions, although it's been labeled as partisan because of the judges that are typically originalists. But I think it's the most neutral way that goes to the core of our founding. So that way you're not you're not tethering your meaning to something you're not untethering the meaning to the tides of the time. And it's the ability to keep what the framers meant so long ago, so that way our society doesn't go awry.
Yeah, I think ultimately the Constitution doesn't really belong to judges themselves. So this conversation about Thomas versus Breyer versus Roberts versus whatever, I mean, I'm not sure that's the right question to even ask. The Constitution belongs to the people of the country. And when I think Justice Thomas has been most prominent in recognizing that, and his perspective is essentially that to interpret laws based on anything but their meaning usurps the power of the people to have their constitution. It's this idea that the stability of the rule of law, of our constitutional order, require us to take this approach because it's the only one that makes sense. It's that, or we just kind of make it up as we go. And that sort of making it up approach may have compelling rationales, moral, policy, logically, philosophically, whatever. But ultimately, whatever those rationales are, the sort of make it up approach ultimately destabilizes the constitutional order. And if for no other reason than to not have everything fall apart in shambles, this is how we ought to interpret the Constitution. And that's really what the baseline is. And sure, it sounds dramatic a little bit, I suppose, but there's some really interesting, consequences if we don't take this approach. The president has to be, of a certain age, and senators have to have certain residencies, and all of this is in text. And what happens if we just decide to ignore that? Okay, well, then that makes no sense. We're just ignoring them for no reason. You have a right to keep and bear arms. Okay, so what if we just decide we didn't really mean that? Sorry, never mind. It's just the illogical consequences of just ignoring the text are just too numerous to even articulate. It just destabilizes the nation and our politic on a whole.
Yeah, and I would ask people who dislike Clarence Thomas, would you prefer if Clarence Thomas was writing his opinions based off of his personal beliefs? Or do you think that would be worse than what he's providing you already? It goes all the ways. Like what's restraining for one justice is restraining for the other. So I think people should really stop for a moment and think about the idea of what Clarence Thomas and Justice Alito would be doing if they were just voting according to their personal beliefs on what they want. I'm not sure there would be a more progressive friendly vision of America than what we're getting. So I think there's a sort of and the same reason why we believe in due process and free speech is it's you never know when your enemies are going to be in charge. And that's a big part of originalism, is it removes that aspect of
Originalism has the text as the standard as compared to your individual or a judge's individual perspective, their ideology, so to say.
Mm-hmm. Yeah. And
that binding is not just temporal, but requires us to continue that guideline from generation to generation. It's that sort of, we talk about stability, not just in the short term, but in terms of the life of the republic, right? So from generation to generation, it requires us to have this sort of stability. And as a result, we get better interpretive results from this approach.
I really like how that's coming along. Before I ask my next question, I just want to remind everyone, if you are watching this either on Zoom or on Facebook, please ask your questions. We're going to get to them here in just a minute. And if you're on Facebook, can you do me a favor? Go ahead and share the stream with on your timeline. That way, all your friends can see this, and they can all understand what you're getting here. So, Brandon, you touched on this a little bit. Kaitlyn and David help me out here. Mountain States and a lot of other similar foundations, we like originalism. We argue from it. How have we been using originalism in our fight for our clients? And now, Brandon, how have you been using it for the state of Tennessee?
So earlier this year, Erin Earhart and I, she's another attorney at Mountain States, we filed an amicus brief in the Kennedy versus Bremerton School District case. That was the case about the coach, the public high school coach that was praying on the 50-yard line.
That was just decided recently, right?
Yes.
Yeah.
So we used originalism principles in our amicus brief. So we talked about what the Establishment Clause meant at the time that it was ratified, and what the framers were worried about was the intrusion into their conscience. So national religion, and they were worried about being coerced financially to support a national church. So he said that there's no way that Coach Kennedy's prayer on the 50-yard line, that is not coercing anybody to do anything, would fall under the Establishment Clause as it was originally understood. So that's how we used originalism. This is a very short explanation. If you'd like to read our full brief, I'm sure you can find it on our website. But we use originalism to support our point, and Coach Kennedy ultimately prevailed.
Yeah, and I should offer the disclaimer that I am, of course, not speaking on behalf of the state of Tennessee in any of these comments, and blah, et cetera, et cetera. But I think one thing you see, not just in Tennessee, because Tennessee, like a lot of states, works hand in hand with other AG offices and solicitors general. But I think what you see a lot of at the state level is applying these principles to sort of core issues of federalism and structure in particular. The rights questions, like freedom of religion, like Kaitlyn brought up, are really important, but I think the state's role in this is often more relevant in defending the basic structures of the Constitution, the principles of federalism, the pushing back on coercive spending clause programs that seem to disrupt state prerogatives and destroy the dual sovereignty that states have.
Commerce clause abuse, right?
Yeah, well, that's a classic, but I would also encourage everyone, maybe this is not an appropriate thing to do, but to check out Philip Hamburger's new book, Purchasing Submission, which is a really apt analysis of how just the spending clause itself and some of these large federal programs serve as a fundamental threat to our federalist structure. These sort of like big structure questions, I think, are really fun and important because they're structural. They're literally the structure of how our government works. And I think that's where I think states in particular have been really active. States have been really actively engaged on a lot of what I would call the more rights questions. And that's, so the states were in with Mountain States Legal Foundation. Likewise, we also filed briefs in defense of Coach Kennedy in the Bremerton case. And we've also filed individual rights related briefs and free speech and Fourth Amendment and many other sort of these rights cases. But I think the states have a particular role, and only really since about the early 2000s have we seen state AG's offices really start to stand up as the final line of defense of federalism. And that's, really remarkable. It wasn't until the NFIB v. Sebelius, the first of the big Obamacare cases, came out that a majority of the states had sued the federal government. It was a pretty remarkable moment when 26 states filed a lawsuit against the United States federal government. And now we see this sort of stuff as relatively common. And it's resulted, this is a pitch to all the law students out there, by the way, to go work back at your state AG office when you graduate. But it's actually resulted in just some really remarkably interesting and fun litigation that states can bring. One example is a case that Tennessee co-led that largely due to how some silly procedural rules worked out. We ended up being lead on the OSHA vaccination mandate case. That's a fun case to work on. And that's the sort of stuff you get to do if you're a state and representing this. And there's an important role for states within their federalist structure to exercise their authority to push back on federal overreach and vindicate the rights of their citizens. And, not to get too much into the push to why you should go work for state government, but it's a heck of a lot of fun. And if you're thinking about what you want to do with your career and if you're a law student out there, then this is definitely something to consider.
Gus got that 20 state injunction against the Title IX interpretation as well, along with a lot of other states too.
Yep, that was, yeah.
So while you're in law school, come be a fellow at Mountain States Legal Foundation, and then go work for a state attorney general.
Yeah, you got 2 summers.
You got 2 summers.
I will say it's really common for the state AG's offices to be hand in hand with groups like Mountain State or Pacific Legal. I mean, you guys know this, but we're often engaging in a lot of the same types of casework and stuff, which I think is fun. It's good to have partners out there, so we're not always alone.
So I've got a couple questions coming in here. So if you've got a question burning in your mind, this is the time to ask it. Joe from Colorado, he has a hypothetical for you all. I'm going to read it. It's a little long, but it's a great one. Suppose that after 100 years of settled, uncontested, well worked out Supreme Court precedent, under what everyone supposed what the original meaning of the provision was, based on various government decisions or agencies that have been structured, new scholarship comes out and proves that the original meaning of the provision is irreconcilable with the 100-year-old precedent. Is the Supreme Court now obligated to reverse 100 years of settled law at the first opportunity, even if it causes dramatic consequences so that everyone agrees, or do they keep it? Well, what do you say to that? Precedent versus original meaning.
Joe sounds like a lawyer.
Joe might be a lawyer.
I would say they're absolutely obligated to go revisit the precedent. If the precedent's wrong, the precedent's wrong, the precedent's wrong, the precedent's wrong. The Constitution is the law of the land, not the opinion of 9 individuals in robes. As much as we may balk at the potential consequences that such a decision would have, I think the responsibility for responding to those potential consequences lies in the legislature. The court should not be making that kind of judgment. They should be determining what the Constitution means.
I have another good quote for you that will answer your question. Justice Douglas said that it is the Constitution which a justice swore to support and defend, not the gloss which his predecessors may have put on it. So,
ooh, I like that.
Yeah, I generally agree. I mean, the principles of stare decisis or of respecting precedent for the sake of stability is not something to be completely thrown overboard. But in the hypothetical we have here, there doesn't seem to be a lot of room for doubt. We're talking about a very clearly irreconcilable precedent, and if that's the case, then reconsideration and withdrawal and overturning is definitely warranted. Now, I will say that this is not usually as dramatic as opponents to this position would like you to think it is. I think Dobbs is instructive on this front, where the Dobbs decision overturned not 100, but a fair amount of precedent that has been around for decades and decades. Granted, it was a very contested precedent, but the result has not destroyed the country. Nothing's really fallen apart in the meantime. States are able to deal with this. And I think often especially when a federal court is overturning bad precedent, frequently the solution then is that we rely then on states to fill in the gap like they were supposed to do in the first place. So it's not like there's just some Wild West lawless, nation out there if the federal government doesn't tell us what to do. The states have and can and do handle some of these really important, complex questions, not just as a matter of frequency, but as a matter of efficacy and quality, tend to do it better and more efficiently than the federal government can. So I agree with David and Kaitlyn, but I mean, let's be honest, these consequences of overturning precedent really are never as bad or dramatic as they're alleged to be. And kind of secondary to that, the court has shown an ability to do this in the past in a way that sort of allows time for people to adjust or to fix these problems. And there is a constitutional originalist method to fix these problems. It's called amending the Constitution. This is, I may be wrong, but I think this might be the longest period in history that we've gone, definitely in the modern era and maybe ever, without amending the Constitution. And I think part of that is because of this legal realism movement of let's just make the Constitution mean what we want it to mean instead of putting in the hard democratic political work of getting the people to propose on, agree, and decide to change the text of the Constitution. I mean, overturning precedent doesn't mean you can't change the law. It just means you should go the proper way if you want to change the law. And that's the intended structure. That's what we should be doing.
Yeah, I think intellectual humility is very key here, because in the hypo, it's okay. We know for a fact this is incontrovertible, but in the real world, it tends to be a lot more messy. If other judges have been saying that this means one thing for 100 years, and you're the first one to come up with this brilliant insight that they're all wrong, like that's generally a very good sign that you should stop, pause, think, discuss. So it's important. It's like, usually you're not the one person who figured it all out and everyone else is a crazy person. So it's important to when you're in situations where you might make big changes like that, like you make sure you understand why Chesterton put his fence there. Like it's important to do that.
Is there an example of that where maybe there was such a long-standing precedent? I know we talked about Dobbs and Roe v. Wade. Is there another that wasn't so, I don't know, so contentious perhaps?
Korematsu comes to mind. This is the case that wasn't quite 100 years, but about 85, 90 years. The case that upheld the Japanese internment camps during World War II was technically good law. It wasn't only recently that the court sort of in passing said, oh, by the way, as we all know, this decision is just in the ash heap of history now.
By the way.
I mean, technically, no, we didn't know that. It was an interesting moment. And so there are precedents like that are clearly wrong. And often I think what happens in practice rather is that bad precedents are usually just ignored. If there's something that was this bad, so I don't think there's a lot of examples of something that we've been interpreting for 100 years and then suddenly we realize it's wrong, so we stop doing that. I think as David said, it's often a lot messier. The Dobbs case is a good example of this. The Second Amendment line of cases are good examples of this. You're talking about two relatively important to the public issues that took decades of chipping away and developing jurisprudence and thinking about and finding consensus within the courts to really get to decisions that exonerated these rights. So I think that's in practice what happens. It's not often there's such an obvious mistake. I think of what's the conspiracy theory out there that there's reproductions of the constitutions left out an errant comma.
Oh yeah, the errant comma. Yeah,
oh my goodness.
Like and the comma could in theory change the entire meaning and implication of the takings clause. And I think the real answer there is it's probably just a smudge from the ink, not like some great mistake of constitutional interpretation. That sort of stuff just doesn't really exist. But I think the core question, the one that's more interesting, is when it comes to constitutional text, as David said, the Constitution says what it says, what it says, what it says. It's not something that you're really supposed to be just making up as you go along. And we can talk about what the text means or what it means in context, but that, again, originalism is asking or is telling us what questions to ask. It doesn't necessarily give us the answers to those questions.
Yeah, that mention of the errant comma reminded me of my favorite constitutional conspiracy theory, because apparently there are more than one, is that actually executive power was rewritten by Gouverneur Morris, who was a big proponent of executive power, and that he deliberately left out the executive powers herein granted that are in, you see it in Article 1 talking about Congress, you see it talking about the judicial branch. The executive branch notably does not have any restrictions on it. Just the executive power is hereby granted. I haven't looked deeply enough to know if this is true, but there's at least an argument there that was kind of bureaucratic deep state meddling at the Constitutional Convention that changed what the framers thought they were writing. But ultimately that was the text ratified by the people. So that is the text of the Constitution. So again, it doesn't matter the evil in Governor Morris's heart. But I think that there are weird issues that could potentially come out where you're like, yeah, we've been getting this wrong for 200 years. And luckily we haven't seen any like major chinks of the armor come out of that, but it's possible.
I think part of that too is because lawyers are obnoxious. I mean, thorough, and of course, tend to go after these arguments as quickly as possible. We're not just sitting around thinking about this aimlessly. Lawyers tend to be highly motivated, financially or otherwise, to get in and develop and find arguments that help our clients and our positions in cases. So it's just not super common where there's going to be some mysterious 200-year-old precedent that we suddenly realize needs to go versus a 100, I want to go talk about the slaughterhouse cases now, why those were, the precedents coming from that are wrong. And there's a lot of, New Deal era cases that have been around for 100 years that we could take a look at, but we all kind of know those are problematic. That's not like an unknown new thing. We're well aware and think they should go. So
Doug is putting something here in the Q&A. I'm not entirely certain what he's saying, but 12th Amendment 1804, 13th Amendment 1865, the 15th Amendment 1870. I'm not entirely certain, but it looks like he's trying to provide some references here.
That might be back to my comment about how long we've gone since the constitutional amendment.
No, I think you're probably right. So I got another question here from Paul in Florida. Here it is. The courts change over time. Justices come and go. Okay, why is 2022 a prediction of the future? I guess he's asking us, what does the future look like? How does this look for you? What are your predictions or your forecasts if you don't have a magic ball?
I mean, surprisingly, in her confirmation hearings, Ketanji Brown Jackson talked about original intent. We'll see how that goes, but we already have a really strong court already, as you saw with last term, as far as originalism goes. So I'm hopeful.
Yeah, I think it's always a mistake to read the tea leaves, which we're going to do anyway.
Yeah,
but it's always easy to overread patterns into a single term or something. But it really does seem like there was a pattern at the end of this term where the court was saying, okay, Justice Breyer is no longer on the court. We are no longer doing complicated balancing tests. We are no longer balancing the interests of the government against a constitutional right. We don't do that. That seemed, at least to me, like a pretty big sea shift. And barring some sort of tragic accident, it's unlikely that there's going to be a significant change up of the court's makeup in the near future. So I at least am hopeful that this last term gives an indication of kind of how the court intends to approach at least the important kind of constitutional rights cases methodologically. I think he gave a good hint at that. I think we're going to see more of that, and we're going to see, on the other side of that, we're going to see a lot more really, really bad originalism. Now that it's become sort of this is the presumption, this is the everyone has to agree to, this is the consensus of the field now, which results in a lot of people taking their living constitutional arguments, finding a law review article from 1875, chucking it into a footnote and saying, look, originalism. So I think we're going to see a lot of kind of wolf in sheep's clothing originalism in the next couple of years, I think.
That comment reminds me of, I think, New York in their new, you have to have good behavior to own a gun. I think they reference like some colonial era law that said Native Americans can't own guns. And I'm like, is that really how you want to justify preventing your citizens from owning a weapon? That seems really, really bad.
I did love the debates over whether or not it was lawful to own a cannon during the colonial era or not. Those were
definitely
were actually, fun. So this is why lawyers are horrible, because we're all a bunch of nerds who love this conversation. And I think so. Just as far as like what the future holds, and let me preface this with like a caveat. one of the first Supreme Court cases I ever worked on was NFIB v. Sebelius. And I would say work on as in I was like the juniorist guy to the juniorist team on the most minor issue of things that were being worked on during that massive piece of litigation. And so I don't have a lot of love for Justice Roberts in general still, but I will say this, like we are living in Justice Roberts's world, and his, I think, legacy on the court, besides some of the institutionalist stuff, which we could discuss it another day, is turning the court towards its really big focus on structure. Sure, we've had two legal luminaries like Thomas and Scalia who've really driven a lot of that conversation, but Roberts and the Roberts era is one that has been one of focusing on constitutional structure, and I think that's going to continue. And I don't think that's slowing down anytime soon. And that structure, those questions of structure, were not previously as prominent, and I think they will continue to be so for a while. I think the second thing that I would predict is going to be really interesting to see develop, and I think it has the potential to be really impactful on the court and on jurisprudence. And that's this concept of corpus linguistics. So there's some folks at BYU who are doing some really interesting work, and essentially like the very bad short description of corpus linguistics is essentially using AI to better understand the history of words and what they mean. And we're talking reviewing hundreds of thousands of documents and books and pages and words and drawing inferences from use of specific terms and phrases. And I think those sorts of tools are going to help us, I think, combat what I think David described as bad originalism. So I think corpus linguistics is fun and interesting, and go check out those BYU people if you really want to get into it. I'm not an expert by any means, but these sort of tools, I think, so I guess the big picture then is developing tools to be better originalists. I think it's something we're going to see more of going forward.
BYU is actually freely available on their website too. I think that's for anyone to
really awesome.
and play around with it. Yeah.
I read some law review articles on corpus linguistics when we did our Establishment Clause research for the Kennedy amicus, so it's definitely out there.
Yeah. Well, that's exciting. So we're coming to the end of our time, but before we go, we call the show So Neighbor Ask as a way to help people understand these topics and then talk about it with their friends and their neighbors. So kind of a lightning round. If someone comes up to you on the street and say, "Hey, my buddy just asked and I need your help. What's originalism? What's the quick and dirty on this?"
The words mean what they meant when they were written.
All right.
That's the short and sweet version.
I like it. David?
I don't know if I had a whole much to add to that. Yeah, it's texts must be understood according to that. Kaitlyn's is better. Yeah, Kaitlyn's.
I like Kaitlyn's.
Yeah, I'm going with Kaitlyn's also.
Okay.
Yeah.
All right. Well, with that, I think we're going to wrap it up here. I want to thank everyone who's been on Zoom and on Facebook. Thank you for joining us. And thank you to Brandon for being our great special guest. You were just a delight here. Within a week, we're going to have this webinar uploaded to YouTube and everywhere else for your future viewing. In the meantime, do be sure to keep up to date with all of our important work at our website, mslegal.org. And you can follow us on Twitter at MSLF. Instagram at Mountain States Legal, or you can find us on Facebook. With that, thank you again. We look forward to seeing you next month for our Constitution Day special. So thank you, everyone. Have a good time.
Thank you.
Thank you.